professors here from VLS that are here to talk about and inform you guys of what's going on. We have Professor Anna Saxman, Professor Margaret Berry, and Professor Robert Sand. So can you guys give us a little bit of background information of what your experience has been with bail and how your clients have dealt with bail in the past and how bail reform has become such an issue, why bail reform has become such an issue over the years?
I'm going to start because I'm the interloper here.
Okay.
I have a defense attorney on one side and a prosecutor on the other.
Former.
Prosecutor on this side and a defense attorney. I'm not a criminal law litigator. I never did that except when I was in law school. That's basically all I did in law school, but that's another story. So I'm going to let them answer and then maybe come in with a more general. But first, see those folks who look so comfortable and disengaged in the back? We want you in the conversation.
Going quickly. Because I've been in practice for a really long time, I can tell you that in the last 30 years, the amounts of bail that have been requested by prosecutors went up incredibly in the, I'd say, the last 15 or 20 years. Lucky for us, in some counties in Vermont, that trend is being reversed. Not all counties, though. So what the defense attorneys do, if they're doing it well, is to try to bring to the court all the reasons why the court shouldn't listen to this arbitrary large amount of bail that the prosecutor may be asking for, and instead look at this person as an individual. One way that I have seen discrimination seep into the bail decisions really has to do with who's been here longest. A lot of the judges in Vermont and many of the prosecutors believe that if your grandparents were born here and you've only ever lived in Tunbridge, that you're less likely to fail to appear. But in fact, so people who are more recently here, who may not have a whole, grandparents, parents, are at a disadvantage. And this often falls on people of color who may not have the same kinds of community connections. So what we try to do, and Patty Lancaster's been doing this possibly longer than I have, is to show the court that there are other things you can look at other than have they lived in this one place. That you can see, possibly there's a person from a church, there may be a person from a job, there may be other connections, and also that this person came to Vermont, generally speaking, because they wanted to be here. Does it always work? No. We do have, I think, pretrial detention is higher, I think, for African Americans than for whites, just overall. And I could go on and on, but I think Bobby wants to jump in.
Okay. Are you done?
Okay,
I have lots to say.
I can jump in too,
I don't know.
We also have
This
questions.
is a conversation, so I figured after you said I'd get rebuttal.
We'll let you all in a minute.
We're not gonna disagree. So some of our earlier speakers mentioned this, but if an individual is charged with an offense and for whatever reason fails to show up for a court hearing, including back in the old days, failing to show up for a hearing to discuss why a fine hadn't been paid in full, there's a notation, a flag that's put on their criminal record, FA. And if that person ever again is charged with a new crime, I promise you, the prosecutor will make reference to the failure to appear and will argue that because there was a past failure to appear on an old charge, the person now presents as a risk of flight or non-appearance sufficient to justify the imposition of monetary bail. Judges tend to accept prosecutors' recommendations, particularly if there's media in the room, and an individual gets held without bail. And here is the extraordinary perversion of our system. The person sits in jail due to an inability to post bail at a time when they are constitutionally presumed innocent, and the way they secure their freedom is to change their plea and agree to be found guilty in order to be released. That is totally backwards. And there are so many things wrong with that. One aspect that is wrong is that the bail system and the statutory situations in which bail can be imposed need to be fixed.
So I just want to add a little bit to that, which is in the years that I practiced in DC, we were on the other side where I was representing the victim of assault. So when arrest happened, we knew we had, depending on when they were arrested, between 24 and 48 hours to figure out our plan of protection, because that person was going to be on the street. And the reason was, we weren't thinking that bail would hold them in, because in DC, they don't set bail. And I just wanted to give you a little bit of a quote from a story out of the Washington Post. On a typical afternoon, the DC Superior Court will release about 90% of the people who've been arrested and held overnight in the nation's capital. They're released without leaving behind any money, on a promise to return to court and meet conditions such as checking in with the pretrial officer or reporting for drug testing. This is not how the system works for those charged in almost every other local and state court in the country, but it is how the district has run its courthouse for more than 2 decades. And Judge Morrison, who I practiced in front of quite a bit, is quoted as saying, "There's no evidence you need money to get people back in court. It's irrational, ineffective, unsafe, and profoundly unfair." And that's what we're talking about today. It's profoundly unfair how this plays out across the country. And there's no more of a failure rate of people showing up for court hearings in DC than there is in all these other places where bail is considered so important. And we saw today in the films the impact of setting bail for people who can't pay. It destroys lives.
So one of the questions that we wanted to present was, what does bail reform mean? Can you go into detail about what exactly needs to be reformed in regards to bail? Are there specific statutes or?
So there's an easy answer and a much more complicated answer. And the easy answer is embodied in the bill that our first speaker spoke about, and that is to change who can have cash bail imposed on them. So in Vermont, an individual who poses a risk of flight or non-appearance can have monetary bail imposed upon them. Well, there are people who have never left the state of Vermont. Maybe they got adventuresome and crossed the Connecticut River and went to New Hampshire, but they are not going anywhere. But because of the complexity of their lives, because keeping appointments maybe wasn't something that they grew up with, they just have trouble showing up for court. It is insane to impose monetary bail on those people that can result in their being arrested and incarcerated simply for failing to appear. There are much smarter ways to address it. So a simple component of bail reform is to say only people who pose a legitimate risk of flight, who we think are going to flee prosecution, flee the jurisdiction, can have cash bail set on them. And risk of non-appearance, we're going to deal with that some other ways, perhaps through text messaging, perhaps through some other systems.
Well, yes, I agree. We could do what they did in DC, what they've done in New Jersey, which is no money bail for minor offenses. I'm sure you probably know this, but as a professor, I just like to say it again, you know, money bail is only allowed to be set to assure the presence of the defendant at trial. But under the Eighth Amendment, judges don't have to consider ability to pay. Currently, some brilliant law students and recent grads around the country are challenging these kinds of bail practices as violating equal protection, treating poor people differently than people who can afford to get out.
And one of those is University of Maryland's criminal law clinic, where they challenged the lack of counsel at bail hearings, because you think, right, you look on TV and you hear about Miranda rights, and you think, oh, you get an attorney right away, right? I hear the police saying that. Well, Miranda doesn't get you an attorney right away. And as a matter of fact, when you're arrested and they're setting bail, you're not assured of an attorney either, because the analysis is what's a critical stage of your criminal prosecution, and the bail hearing, the initial bail hearing, is not considered that. At least Supreme Court hasn't said that yet. And so a lot of people are facing this very important determination. Are you going to sit in jail until trial? They're facing that very important determination on their own. And all these wonderful things that you're supposed to argue about, flight and risk of flight and so on. You're locked up, you're scared, you don't know what those analyses are, you don't know the constitutional issues, you don't know what you're supposed to argue, but you're supposed to get in there and convince someone that you're not supposed to sit in jail until your trial. So this lack of counsel is something that University of Maryland Law School Clinic challenged Maryland and got a Supreme Court ruling that said, you're right, you need an attorney at that point. And legislation followed, so that in the state of Maryland, and there are other states across the country, are beginning to say, no, the Supreme Court hasn't said it, but this initial bail setting, that's a critical stage, because otherwise you're sitting in jail, and guess what you want to do when you're sitting in jail? For many, many reasons, you need to get out. One, it's scary. Two, you're losing your job, maybe, child custody, maybe, housing, maybe, and you're not able to help prepare your case. Why? Because you're sitting in jail. So all of this cascading set of negative effects are coming because you can't get out. And what happens to our presumption of innocence when that's the framework that we're in?
It's a tremendous power that prosecutors can use in order to incentivize someone to take a plea.
Bail is leverage.
It's leverage.
And prosecutors have extraordinary leverage already, and that just increases exponentially when defendants get held pre-trial.
So I want to go into a little bit more about the role of prosecutors. Do they have a role in the discriminatory way that bail is set? Do they have a say? Can they help control the amount and how bail is set?
I think it's probably fair to say that most requests by prosecutors get honored, and most requests about conditions of release and monetary bail made by prosecutors get honored. So prosecutors do that for legitimate and not so legitimate reasons, but it takes a lot of judicial courage, particularly in a higher profile case, but really in any sort of case, for a judge to reject a prosecutor's request. Because who owns the bad outcome at that point? The judge does. So as the Attorney General said, the easy thing to do is ask for bail, ask for incarceration. No prosecutor, at least so far not in this country, has ever gotten in trouble for asking for more punishment and more bail. The trouble has always come when someone's been willing to take a risk. So prosecutors, I'm sorry, I'm rambling, I've forgotten the question. Prosecutors absolutely have a role. I actually think that the best fix comes legislatively, where the legislature more clearly articulates the boundaries and parameters of permissible bail, and through statutory revision creates the political cover so that more courage can get exercised in the criminal justice system.
And I think, I just want to add, it gets back to that vigilance in the community, because that legislation is one step away from a really bad thing happening, a crime that everyone gets outraged about, and all this hard work falls apart. So trying to build a base within the community where people don't look at the exceptional incident and say, oh, wait a minute, we've got to crack down. We've got to change this whole structure. I mean, that's how we got to 3 strikes laws, right? This is how we got to this situation we're in, where so many people are locked up. You know, we've got to just keep the work going, because if we get this great bill, HB 728, passed that knocks back bail, what else are we going to do to kind of keep the energy going that will help people protect that and realize that, you know, the next bad thing that happens don't mean we throw it out the window?
The next question is, how does race play a part in who gets released on bail and who has to stay in prison?
Well, I've kind of mentioned that. Do you want to chime in? Well, places in the criminal justice proceedings where there's a lot of discretion is an area where bias, implied bias, whatever you want to call it, can come in. And studies of many jurisdictions outside of here have shown that, in fact, it comes in at bail. I mean, it's charging decisions, bail decisions, ultimately sentencing, et cetera.
Step it back to arrest, don't forget that.
Well, yes, step it back to arrest. But, so that's where it comes. We found in Vermont, young African-American young boys and men who were charged with minor delinquencies are less likely to be released back to their families than white kids.
In looking at risk of non-appearance, one of the things that judges look at is what are the connections of the individual to their community. So people who have, you know, been multi-generation in Vermont or own a home get to advance arguments that young people or newer arrivers to Vermont or poor people who don't have property are unable to advance. And so that isn't explicitly or overtly race-based, but it certainly ends up disproportionately adversely affecting the poor and people of color.
And if you get back to this idea of the empathy that T.J. Donovan talked about, you know, I went to school with these kids. I know what they're like. You know, I can empathize with them. Well, a lot of those connections aren't being made when you're talking about people of color, because that's other on so many levels. And so we see that playing out, whether it's conscious or not. It plays out in the decisions of whether that person will show up, whether we can rely on this family to bring them here. Who are they?
How do we increase the conversation in law school and in the classroom?
Well, we're doing it in the classroom.
Well, on a broader scale, how can law schools inform their students? What's the best mechanism to inform law students of the issue and what's going on?
I would think a Black Law Students Association conference on bail.
Called Race and the Law.
We are within 1 hour of 4 different criminal courts, and I've always felt like that was an underutilized resource at VLS to actually see the system in operation. You know, some of my classes we get to take a field trip, but that's it seems like we should do that more often. And not that the classroom discussions aren't vitally important, but actually seeing the system in operation and gaining an understanding of how it's not so wholly different from conveyor belt justice in some aspects, and that may give us insight into how do we humanize an approach that has largely become rather dehumanized.
And other states have law students involved in trying in some ways to mitigate. There's the $1 a day in New York, where students are actually, in cases where people get charged with 2 crimes and maybe they've resolved one, there's only $1 on the other one, but the client often doesn't know that, and so they're held in jail because they haven't paid that $1. So the students are going to the court, paying the $1, and getting the person out of jail. That kind of activism can really do a lot. Not necessarily here, because I don't think that's happening, but there are all kinds of interesting things that students can do. And you can look at the equal protection challenges that are being brought in other states, and at least one of our students is doing a tremendous amount of work on the statistics of race-based stops, and that's another area which can contribute to that.
So what is the best way for, what does bail look like in the future? What should it look like in the future? I know we
Remember I
touched on
said
it a little
No
bit.
bail? That's how it
No
should
bail,
look.
okay.
Except, yeah, I mean, currently, the way the law works is that if you've been charged with a life imprisonment case or a violence, you may be held without any bail because you're perceived to be so dangerous. So those cases are sort of aside. It's the money bail cases that I think we could really get rid of.
I'm not prepared to say never monetary bail. I can certainly see a situation where, notwithstanding all other reasonable, appropriate efforts to secure appearance, someone just continues to keep showing up in flagrant defiance of the court. And at some point, I do think one could say enough is enough. The problem is, we say that right out of the starting block. But certainly, as an initial response, monetary bail is grossly overused and should be virtually eliminated.
And there's no way to, the person who can pay that easily or readily, or even with a little effort, is always in a better place, so it's inherently discriminatory. So if we look back to, was it Ty this morning in the video? Ty's family was completely ruined just trying to get her out of jail. And why should Ty, because her family's poor, have to put down $10,000 that they'll never see again? So one step might be at least to do unsecured bonds, because the court can do that. You don't have to have, go to the bail bondsman if the court will accept an unsecured bond, meaning if you don't show up, you owe the $100,000 in Ty's case. But if you show up, which Ty was clearly going to do, you're not out $10,000. Why should we have a system that sets that up so that poor people's lives are ruined before we even figure out if she's done anything wrong? This is from Jump Start.
But bail reform is also criminal code reform. So we've had massive over-criminalization, over-penalization. So we should be looking at substantial decriminalization, not necessarily no response, but a response through a ticketing process as opposed to an arrest process. We should not be criminalizing addiction, and self-harming behavior ought not to be criminal. So if we can ever adopt a true public health approach to substance abuse, that removes substantial number of cases from the criminal justice system, which aids in bail reform. Sorry for editorializing.
And there are those people you do want locked up, even pending trial, when you know that there's a history. I talked about my experience in DC. we had 48 hours. We knew we were running. Why? Because when that person came out, they were coming back for my client. We knew it. So there's got to be something that you're doing for those kinds of highly violent, dangerous cases. But so many of the cases we're talking about have nothing to do with that. And we're locking folks up for much longer periods of time.
I should just say, in 22 years as a prosecutor, there was one defendant who took off who we never found. To this day, no one knows where he is. But we did about 2,000 cases a year. So you do the math, it's not complicated, but it is for me. People, it's hard to hide. And so there's this myth that somehow we're going to lose track of people, and that simply doesn't happen. I mean, I think there was some experiment about someone who tried to go completely off the grid, and that person couldn't do it. So we have this mythology or this distorted fear that we're somehow going to lose track of people, and so we need to hold on to them. And it's not borne out by reality.
It's true, and it's hard to get lost in this country.
You can't get lost.
The few people that I know who did take off were always found and brought back, and then they were in jail. So, what else?
Well, she got on that list.
Now's the time that you guys can come up and ask questions to our panelists. We're going to take the last couple minutes of this panel to do so.
Don't be shy. I think there's a microphone up here.
I'm not a student. Do you mind last couple questions?
No. Well, I don't.
As a bondsman myself, I understand that guidelines do need to be in place. There does need to be some bail reform in place, but the state uses a lot of different assessment tools, sentencing guidelines, assessment tools for community services, and as I was talking with Attorney General Donovan, the state really needs to have some type of bail assessment tool that they have to go by. I mean, something that they can go and say, this is a first-time offender, he lives in the state, he has no failures to appear, boom. It doesn't matter what he looks like or what his race is, this is where it falls. It's a tool that they have to go by. If they have that failure to appear, boom, it takes you over here to this category. I mean, I worked for probation parole for 9 years. I did pre-sentencing guidelines for many offenders, and that's what we went by. We didn't go by the guy was a jerk and I didn't like how he talked to me. We went by what the guidelines said he had to go by. So that's one thing I'm thinking that would be a big reform tool. And it'll be a lot easier for bondsmen and other law enforcement officials to swallow that kind of change than to say, oh, no bail's needed, because that's just baloney. Because I've dealt with this system for a lot of years, and I have some pretty dangerous people that have to call in and check in with me once a week, and you're glad that they do, because if they don't, I go get them. The next thing I got is the disparity in the numbers. I'm not seeing a lot of, when it comes to like my drug cases and stuff, when we're talking people of color, I'm not seeing a lot of the possession charges and stuff. What I'm seeing mostly is like transporting drugs from out of state. And that immediately, whether you're a court clerk, and I was a court clerk as well for 6 years, so I really know this system inside now, that immediately tells me that they're automatic flight risk. They're already coming in from out of state. So something has to be put into place that's going to guarantee that they're going to come back to Vermont to show up. I mean, a lot of people that have drug problems and dependencies are totally unreliable. I have family members, I mean, they're just off the wall. You just don't know what they're going to do. They're just totally unpredictable. They're my worst cases that I have to deal with is when I have to deal with addicts, and I get them calls, honest to God, every day. People sitting in jail want to get out. They say, I'm sick, I can't get my medicine in here, and they want to get out. And so that's another area. And
maybe we can answer those, and then we'll get some other questions from folks. Thanks. So the use of risk assessment instruments is really interesting. Vermont uses something called the ORAS, the Ohio Risk Assessment Survey, and it can be useful. There is another tool developed by the Arnold Foundation that is a static instrument, so you don't have to interview the person, but it looks at a history of fixed factors to determine whether someone is likely to appear or not, and there's been some pretty good results from that. The risk of using any type of instrument like that is there bias, was there bias inherent in the creation of the factors that are being used to come up with the purported objective number? And I'm not enough of an expert in the field to say other than, of course, one's bias is going to influence the kinds of questions that you're asking to end up producing what looks to be an objective factor. There's very few things that are purely objective factors.
Well, and bail is required to be an individualized determination, which gives the opportunity, if there is time and effort, for the defense to actually present, real information about someone. Yes, this person, used to live in Brooklyn, yes, etc. But here's what he's got. His mother is a security guard. His father works for so-and-so. They're willing to take him back and really watch him like a hawk, etc. Really, facts about an individual may be more important than a grid, a check the box. Any other questions?
Hello, good afternoon. My name is Latif Munir. I'm a 1L here at Vermont Law School. And my question is, when the Attorney General spoke, he mentioned that housing an inmate essentially costs roughly $40,000 to $50,000+. To me, that sounds like a scholarship. That's like scholarship money. So how do we get the criminal justice system to sway towards education and educating people who offend, who are, on their way to jail or anything like that? But how do we get in a sphere to where we can use education as an incentive to satisfy their requirements instead of simply jail time where the state is just spending money, or we could just educate them, whether it's somebody who didn't graduate high school, they get a GED, somebody who is older, somebody go to trade school, something like that. Just something educationally that can have them doing something else and be productive in other ways as opposed to doing crimes and things of that nature.
One way to do that is to elect people who are going to pursue those solutions and then hold them accountable. Because it's not up to the Department of Corrections, for example, to make those choices about what happens prior to people landing there. But what are the structures that we want to have and that we want to hold people accountable for doing on our behalf that will be put in place? And it takes a lot of work. So that's one answer. I don't know that's the only one. So.
There have been programs over the years. Is it still true, Patty, that if you get into the Vermont prison system and you don't have a high school diploma, that you do, not a GED, you go to school and you get a high school diploma, and that helps.
So
I don't want those young
Are those
people.
still in place? 'Cause
Yes.
I think so,
Are they?
yes.
Are they?
23, yeah.
Oh, go ahead.
And I think, clearly that's important, although I wish that young people weren't in jail in the first place. But there have been a number of programs over the years, life skills, this and that. But truthfully, we'd like the sentences to be shorter and the focus and the money to be spent on, re-entry, housing, helping people to get back into their communities and get on their feet.
It's a little depressing, but the largest high school in Vermont is the Community High School of Vermont, which is the Department of Corrections High School. One of the things that the Attorney General did so compellingly, I think, is talk about how criminal justice reform is really societal reform. And early on, he recognized when he was the Chittenden State's attorney that the same folks who were showing up in the ER to get their medical care were often the same folks who were coming into the criminal justice system, who were often the same folks connecting with social services in other areas. And so absolutely we need criminal justice reform, but that's not going to be enough of a fix. So more specifically related to your question, college savings accounts for every person born in the state, the use of incentives early on will ultimately be much more powerful change mechanisms than bail reform or sentencing reform. Not that those things aren't important, they're not systemic agents for change.
Right. And I believe the Attorney General talked about opportunity for a lot of these kids that are getting in trouble. The school systems aren't there, and they're underfunded, and they just don't have the opportunities that other people have. So I appreciate the answer, guys.
And I would just also say, and then fix it.
Right.
TJ was very good about that. That's your,
Fix it.
we're professors. It's your job to fix it.
Hi. So first of all, I just want to thank Balsa and the panelists for opening up this discussion. Thanks. My question is, we've been talking about biases and implicit biases. So as advocates and future advocates and people in our communities, what kind of tools should we have and work on to try and combat these explicit and implicit biases?
I mean, it's a question that is so loaded with the possibilities for addressing it. I mean, when you think about what's happening in the criminal justice system, it's so multi-layered, right? It starts with how communities feel about crime, the things we criminalize, who ends up in jail, and what that says about how we as a society view certain people. So where do we start with that? And I think that was the pause that you were hearing is, where do you start with that? And we start in part by building awareness, I hope, in our communities. So many people that I find myself talking about the criminal justice system with say, oh my goodness, I didn't know that was happening. Really? And part of me is like, well, why don't we know that's happening? And is it because we don't care enough to know? The urban legends around why we need to lock people up and how bad these people are and those people are just are profound, right? People aren't connecting with other people and thinking what it means when someone's locked up. I think everyone should have to walk into a cell block. This is what I was doing in law school. I was walking into cell blocks and the doors were going boom, boom, boom at each step. And I was going in there to try and get people out of solitary confinement. So not only were they boomed inside there and in all those layers, but stuck in a cell for months at a time on their own. We're not thinking about that. We're not thinking about what we're doing to people and what it means. And maybe just to walk in there and have that feeling might help. I don't know. Maybe everyone should have to go to the jails that we stick out in the middle of nowhere. And that might help.
I think Margaret said it well, is that in some situations, the defendant is the other to the judge and possibly to the prosecutor.
In the community.
And to many in some communities, yes.
Right, some communities.
And that needs to change. And how can we do that? Well, we can do it by more community forums in which we have people who agree and disagree, people who are upset about drug dealers in their community, people who are worried about their children getting arrested, etc. One minor thing that we've occasionally been doing, I see it more in federal court, is a day in a life video in which we show the judge who this person is, because it's easy for them to say exactly what you said, out-of-state drug dealer. What a terrible thing that is. I've had seen judges say, you people are bringing poison into our community. Now, that doesn't start well for the person. It doesn't look like they're gonna be getting out on bail. And that's gotta change. Because, of course, who's using the drugs in Vermont? It's Vermonters. People wouldn't come here to sell drugs if we weren't using them. So it's a joint problem, be able to see everybody.
I don't have a great answer to your question, but I will say that old property white men have tended to design the systems that affect everyone, and we start to change that, and I think our systems start to change.
And that change agency is not a one-shot deal, right? It takes real commitment on a broad level to building awareness and having people care. And it's hard work. I just wanted to say that.
Hi, thank you. This is wonderful. I'm just going to pose a question that doesn't precisely reflect my views and values, so I'm putting a disclaimer out there. But do you think that judicial term limits would go towards kind of providing that less sense of the other on the bench when you're in a community that's predominantly a community of color, and the people who are kind of holding the door to justice are not reflective of the people who live in that community? Thank you.
Do you have a number in mind?
Over 8, maybe. I don't know. I don't have a number in mind.
And Vermont judges are subject to a yes or no vote every 6 years, yes or no by the legislature.
Vermont put something like that in place now. We have our judge rotations.
We do have rotation, that judges move around the state, but they're still mostly middle to upper class white men.
I don't know that term limits will change that demographic. Another of the same might come in. And I don't, I always feel like it's great to have term limits when I want to get rid of someone. And then when I really like who's there, I'm going, oh my God, that term's going to end. So I'm not, I'm always torn with that solution. I guess maybe Nico, I'm not.
I wonder if we could learn as a culture to age expansively. And so many people age and shut themselves off to new views. We talk about with age comes wisdom, but if you're just narrowing your perspective, the older you get, then that's absolutely not true. So maybe we could create a cultural revolution that helps everyone age expansively. There are people who get wiser as they get older. There are judges who get better the more years they've spent on the bench. So if I had to vote, I'd go thumbs down, but it wouldn't be, it might be tilting downward.
For those of us who plan on practicing environmental law after we leave Vermont Law School, is there something we can do in that field that will help to reform the system?
Without answering you directly, I'm going to say one thing. I think we tend to box ourselves a lot. Okay, I'm going to be a prosecutor, a defense attorney. I'm going to do environmental law. I'm going to do corporate law. I think this is a community-wide problem, what's happening in our criminal justice system. And as a caring member of the community, regardless of what you're doing, this is your issue. And so I really want people to feel that. Don't say it's not what I'm doing. It's what we all have to be doing and all have to care about. So that said, there's more of an answer to what you have, but I just wanted to start with that.
Anna mentioned and TJ mentioned this almost infatuation with establishing otherness, that we somehow, it makes us feel better, or we perceive that it does, to isolate individuals, when in fact we are all connected, and that's true as a human species, and it's true to the environment as well. So the same expansive principles that he's talking about in terms of treating people who come through the system as human beings, I think is broad enough to say that in environmental law and policy, we have to respect all people.
Well, and I'm guessing, and you know more about this than I do, that there are many situations in which poor people's voices in a community about something that's happening environmentally are not necessarily getting heard. And who wants to put the least attractive or the most polluting industry in their neck of the woods because they don't have that kind of, power and voice. So you might be more, thoughtful about that. Patty?
And related to that, Anna, is the
Patty?
disabilities that kids may develop because of the environmental quality in their neighborhoods. So it's all of these. I mean, if we're going to do what TJ recommended, which is transform a society so there are good jobs and clean air and healthy court systems and justice in general, that solves the environmental issue as well. So how to put those together is a great question.
And maybe just to follow up on what Patty said, just one example, if you think about living in a poor community, historically lead had been a real issue there, right? The mental health impact of children exposed to lead is huge, which is why the laws have gotten tighter and tighter. But still, in very poor housing, those issues continue. The impact then leads down the road when you're looking at kids who get into trouble, acting out, and then they're thrown into jail when the real problem is a mental health issue. That's just one example of the environmental impact and why it's important to look at that.
I know there's one student who's,
We've got a patiently waiting student.
there's one student who's working on a paper on creating a mitigating factor within the criminal justice system based upon exposure to lead in Flint, Michigan. So there's a connection and overlap between criminal justice and environmental justice.
You had a question? Yeah.
Oh, yeah, I did have a question. I guess my question is directed at you, Professor Sands. As we know, Vermont has legalized the possession of up to 6 marijuana plants to have in your home. I personally believe that taxation and regulation is on the way, not just at a state level, but at a federal level. With that being said, California is going back 43 years and revisiting marijuana offenses, and I wanted to know, is Vermont doing that, or are they planning on it, or talking about it, or?
So a couple of responses. We have to be careful about possession limits under Vermont law, and there's the sort of walking amount, lawful quantity of an ounce or less. There are distinction between mature plants and immature plants. But yes, I'm not sure California as a state is, but San Francisco, and I mentioned this earlier, is moving to expunge old marijuana convictions. I'm actually testifying on Tuesday at House Judiciary on an expansion to Vermont's expungement law to incorporate some of the changes created by the legalization of marijuana. So yes, we're working on it. The biggest problem with Vermont's expungement law is it's petition-based, which means the individual who was convicted has to wait the statutory number of years and then either care enough or have the wherewithal to file the petition in court, which means gathering a criminal history and actually paying a court fee. And frankly, a lot of people don't know about it, and other people say, screw it, or they can't afford it. So there are some state's attorneys, including the state's attorney in this county, David Cahill, who have said we should have statutory expungement, which means if a certain number of years pass and there is not a new conviction, that old conviction goes off your record, and you don't have to take the affirmative step of filing the petition. We're not there yet, but I think in a few years we may get there in Vermont. You know, just, sorry, so near and dear to my heart, and that's, we have this incredibly well-oiled mechanism for obtaining convictions in this state. If you go to court on a Tuesday down in White River, arraignment day, you see this smooth mechanism. It's not hard to get convicted, but we make it really cumbersome to gain an expungement. And we've even had people from the judiciary suggest that broadening the expungement law might not be a good thing because it's onerous on court staff. And it is, and it might mean we need more staff, but there's nothing in the Constitution or anywhere else that says court should only be there for finding convictions. There's nothing that says court can't be used for good outcomes, and expungements are good outcomes, so whatever impact it has on the system, we should support that and resource the court in a way that allows them to process expungement requests.
Hi. I'm probably one of the few non-lawyers or non-lawyer tracked people here. And just thinking about ways that we can make a difference. How do we fix this system? And it does feel dire and it feels really unfair, but one of the most effective things I think I've been able to do is just bring it up at a family dinner. It's incredibly uncomfortable. I often don't get re-invited, but to just, instead of saying, gosh, did you watch the latest episode of whatever, to say, have you guys heard of like the bail issues we're having in this country? And just getting them engaged and having that uncomfortable conversation and dealing with that potentially racist grandmother, whoever, to start engaging in those conversations. I think if you don't have to be a lawyer, you don't have to be in the legislature, you can just be, someone in the community who wants to just start having those conversations and take the burden off of communities of color, and as a white person, start taking on some of that. And so that's just my 2 cents.
Thank you for that 2 cents.
That was more than 2 cents.
All right, we have about 20 minutes left for the panel.
Oh.
Does anyone have any last minute questions they want to ask, or all right. Do you have any final remarks that you want to give to the audience?
Just a general comment from me, which is I'm so glad to see that some of you were able to stay all day and come at all to this session. And I want to give real credit to Balsa for giving an opportunity for us to have a conversation like this, because with these conversations, hopefully folks are inspired to go out and address these issues and share with other people why these issues are important. And the more we can keep talking about it and being energized about it, the better it'll be for us as change agents. So I really want to thank you for putting this on. Balsa, just a round of applause.
All right.
Thanks a lot. Yeah.